Hey everybody, how's it going? And welcome back to Copper Jacket TV. So today we've got huge news, a major 2A victory out of the state of California. And this is something that we don't get to say often enough, but we've been able to say more often post Bruen. This is thanks to the Honorable Judge William Hayes, and it is a big one. So let's go ahead and talk about it. Now, before we get started, I just want to say thank you all very much for watching. I really do appreciate it. If you are one of those people watching that has not subscribed yet, consider hitting that subscribe button. It's free, it only takes a second, but it helps us spread our message, and it lets the powers that be know that people want to see this type of content. Also, hit that little alarm bell that'll let you know when new videos come out. So with that being said, let's get to it. Okay, so let's go ahead and talk about what's going on here. So there are so many different gun control laws in the state of California that sometimes it's difficult to keep up. At last count, I believe there was more than 100, making it the worst state in the entire country. Now, each one of those laws needs to be overturned, but lately there have been some more high-profile cases that have made their way forward that have to do with some pretty major infringements. One of those is the whole one gun a month scheme, or OGM. It's also known as gun rationing. In the state of California, if you want to get yourself something, you go in and fill out your 4473 and you do this stupid test and you show them this stuff. It's a big old pain. When you go and do that, there is a timer that's set. It's a 30-day timer, and you cannot go in and do it again for 30 days. And you can only get the one, right? So you're stuck at OGM, one gun a month, in the state of California. Absolutely terrible. Well, Judge Hayes just overturned that, saying that it is unconstitutional. Now, this is a really interesting case, and the state of California's arguments in this case were absolutely absurd, and I'm glad that the judge saw how absurd they actually are and issued this summary judgment, which we'll read here in just a second. But basically what we have here post Bruen is the defendants, being the state of California in this case, had to show some type of historical analog, right? Some type of relevant law that is similar to the OGM that they could look back on in 1791 and say, see, this existed. This existed in history. That means that there's a history and tradition that has been upheld until this point. And so our law should be allowed to stand because we found something that is very similar back when the Second Amendment was ratified in 1791. Obviously, they can't do that, right? So what did California decide to do? Well, they looked up laws that regulated the transportation and storage of gunpowder. That's the historical relevance, or the historical analog that they went for. And the judge saw right through that. Basically, California said, well, that law made those regulations because they were going for public safety. It was all about public safety. And our law also goes for public safety as well. I mean, completely ignoring all of the nuances within the two different laws and just saying one's for public safety, this is for public safety, therefore that's our historical analog. It is absolutely laughable. Now, the judge has to determine whether or not the Second Amendment is even implicated. Well, it's very clearly implicated because the people who are the plaintiffs in this case wanted to get more than one in that 1 month period, and they couldn't. Their Second Amendment rights were denied to them during those next 30 days. Okay, so that was obviously a big problem that implicated the Second Amendment. Now it's on the state, it's their burden to prove that there is a historical tradition of this type of regulation, and there's absolutely not. The judge saw right through that and decided that he was going to grant the summary judgment, which is actually a very big deal, and wrote a 24-page order saying why he granted the summary judgment. So this is the part that makes me upset. This is the part that makes you upset. I don't understand why they do this. I think it's just some type of professional courtesy maybe to the state of California. But Judge Hayes placed a 30-day stay on his own order to give California time to appeal. I'm not really sure that that was all that necessary. We know that California has their appeals pretty much ready to go the day of the judgment because California knows they're in the wrong. They know that what they're doing is unconstitutional. They know the judge is going to overturn it. And so California is ready for that. They're ready to appeal, emergency appeal to the Ninth Circuit if they need to. So this judge gave them 30 days to do that. So essentially, the law remains in effect until the Ninth Circuit determines whether or not to grant California's appeal. Now, this case is kind of different from the other cases. So you might look at Bruen, or excuse me, you might look at Duncan, you might look at Miller, you might look at some of these other cases and say, well, the Ninth is just going to play games with this one. And there's a very good, better than good chance that that's exactly what the Ninth Circuit is going to do. But because this is so in your face unconstitutional, it might be hard for the Ninth Circuit to actually look at this one and say that we believe that California has a likelihood of success on the merits, and therefore we're going to reverse the summary judgment, and we're going to, send it back down, or we're going to take another look at it, or whatever. Now, I know that all of the initial excitement from the injunctions and the summary judgments that we've been seeing in the state of California can be absolutely squashed by the appeals and the stays and everything else that comes afterwards. But you have to remember that this is still huge news, because we have a federal district court judge in the state of California who has taken a look at all of the evidence and everything that was provided to him in this case and determined that these plaintiffs' rights were violated and decided to grant the summary judgment in their favor. That is a huge win. If this judge would have determined that California had a likelihood of winning and provided a summary judgment for the state of California, it would have made things infinitely harder moving up to the Ninth Circuit. Because we started off with this huge win, it makes things a lot easier moving up to the Ninth Circuit. And so again, this is a major step. It's a major win. And so I think that we are seeing a huge wave that is heading towards California that is going to restore the rights of its citizens. It might take a little bit longer, obviously, with all the games and the delays that come out of the Ninth, but it's still one step closer to where we should be in that state. And I wanted to share that with you because I've been waiting, and this is a very exciting one. That whole 1 a month thing used to absolutely drive me nuts when I was there. I mean, it's one of the worst in my personal opinion. You get something, you're all excited, then you realize, oh, I need this or that for it, or I need to get another one of these. And they tell you, no, you got to wait 30 days. You got to wait an entire month before you can get something else. It's absolutely ridiculous, and it is a clear-cut violation of the Constitution. So again, I wanted to share that win with you, and I want to thank you all very much for watching. We'll stay on top of this one and see exactly what California and the Ninth decide to do with it. And whatever happens, I will bring it to you at whatever time. Thanks again for watching. You guys have a good one.